This is immigration attorney Parviz Malakouti, and today we're going to talk about the new DREAM Act, the DREAM Act of 2019. The reason I say new is because HR 6, which was the new Dream and Promise Act of 2019, has been split into two bills. It is now HR 2820, which deals with Dreamers, and HR 2821, which deals with TPS. For this video, we're only going to talk about HR 2820, which deals with Dreamers. So if you are a Dreamer, or if you're interested in issues that affect Dreamers, this video is for you. So first of all, let's back up for a second. HR 6, which was the new Dream and Promise Act, was passed in, not passed, it was introduced by House Democrats in March 12th. Since then, it's been split into HR 2820, as we just mentioned, and HR 2821. HR 2820 just passed the House Judiciary Committee for markup last week, May 22nd, 2019. That was introduced by Congresswoman Lucille Elsa Rebal Ayard. That is a Democratic Congresswoman from Los Angeles, where I live, right here, one of my neighbors. And now people are curious about the eligibility requirements and the change in the text of the act. First of all, I did a video on April 9th. I posted that to my channel about HR 6. A lot of the eligibility requirements are the same, okay? We're gonna go through those very quickly, and then I'm gonna focus on what the changes are. So let's get right into it. First of all, before I continue any further, this is not law yet. This is just proposed law. This is an act, so nobody should ever act or do something based off of what they see in this video right now. Secondly, this video is purely for educational purposes. This is not legal advice. Now, let's get into the act of HR 2820. Eligibility requirements. First of all, you have to have 4 years of continuous presence before the application. That's the same as HR 6. Second, you have to have arrived in the United States before you were 18 years old. That remains the same from HR 6. Third, there's an educational component. You have to be admitted to an institute of higher education or technical educational school at the post-secondary level, or you have to have a high school diploma or have a GED. Any one of those, okay, satisfies the third requirement. Fourth, no felonies. Fifth, you can only have a maximum of 2 misdemeanors. You cannot have more than 2 misdemeanors, and you cannot have any crimes involving domestic violence unless you have that conviction as a result of you being a victim of domestic violence, okay? Now, sixth, this is where it gets interesting. There's a new element that was introduced, which is a waiver of potentially a third misdemeanor if you have 3 misdemeanors, and potentially even a 4th misdemeanor. This is how it works. If you have 3 misdemeanors, okay, and you have no convictions in the past 5 years, you can apply to have the 3rd misdemeanor waived, which brings you down to 2 misdemeanors, which of course would qualify you for the act. If you have 4 misdemeanors and no convictions in the past 10 years, you can apply for a waiver of the 3rd and 4th misdemeanor, which brings you down to 2 misdemeanors, which would qualify you for the act. That's new with HR 2820. Next, a topic that I've gotten a lot of questions about, which is 2 grounds of denial, 2 ways that you can be denied. Okay, the first is if you have a misdemeanor conviction or a juvenile delinquency, okay, that led to placement in a detention facility. Okay, if you have one of those and you pose a threat to public safety, you can be denied by DHS for qualification under this act. Okay, so either a misdemeanor conviction or the juvenile delinquency that led to your placement at the detention center, and you have to currently pose a threat to public safety. If that describes you, you could be denied. Second, gang-related activity. If you have any participation in gang-related activity in the past 5 years, you cannot qualify under this act. Now, you don't have to have a conviction for gang-related activity, just participation established by clear and convincing evidence. If there's no conviction, how do they know? The answer is through police reports and through law enforcement databases. Okay, so if you are identified as a gang member that's doing things within the last 5 years, even if you haven't been convicted of anything, and if that's established by clear and convincing evidence, you don't qualify under the act. So again, backing up for a second, what do you get with this? What do you get if you qualify for HR 2820? That's conditional permanent residency. That's basically a permanent residency that lasts 10 years, okay? And during that 10 years, you have the ability to remove that condition. How do you remove the condition? This is how. You need to do 3 things, okay? You need to establish 3 things. First of all, you have to have either a college degree, 2 years towards a college degree, 2 years in the military, or 3 years employment at least at a rate of 75% time. Okay, any one of those four qualifies you for the first requirement to remove the condition. Second, you have to have not abandoned your permanent residence. Oftentimes that happens by leaving the United States, typically for 6 months or more. And then third, you have to satisfy the requirement of Immigration and Naturalization Act, INA 312A, okay, which is typically used in the naturalization context. And basically that is having an understanding of the English language and knowledge of the fundamentals of United States government and history. Now, in the naturalization context, that is a requirement that is very, very easy to satisfy. So if you can communicate in English, if you can write a sentence and read a sentence and know what it means, you typically, you can pass the language requirement. Now, with regards to the knowledge of the fundamentals of the history and government of the United States, again, in the naturalization context, the way it happens is basically there's a question bank of 100 potential questions. You get 10 of those. If you can answer 6 of them correctly, you pass that. And these are easy questions, like who is the vice president? So I don't know exactly how INA 312A would be applied in this context, HR 2820, but if it's anything like it's applied in the naturalization context, those requirements are easy peasy. Okay. Now, if you have that condition removed, okay, because you've satisfied these 3 requirements that we just mentioned, congratulations. Now you have a legal permanent residence, which is a regular green card, okay? And of course, you can apply for citizenship after a certain period of time. That's it for the act. Now, quickly, I want to go over a few questions I got, some really good questions, actually. First of all, do expunged misdemeanors count as a conviction? Excellent question I got here. There is a portion of the act that says that an expunged offense, an expunged conviction does not count as a conviction under this act. I do agree that that's what the text seems to be saying. Now, I was so suspicious of this that I actually contacted the office of Congresswoman Lucille Elsa Raybal Ayard to ask about it. And I've emailed and I've left a message for one of the person who deals with immigration there and specifically dealt with drafting this act. I haven't heard back yet. I'm going to let you guys know as soon as I hear back. But yes, I believe that the act is read to mean that expunged misdemeanors do not count as a conviction. Secondly, does DACA count as part of the 10 years? Not sure exactly what you mean by DACA count as part of the 10 years. Yeah, maybe that person who left that question can clarify in the comment section, and maybe I can follow up in a follow-up video. Next, chances of getting it to pass the Senate and Trump signing it. I wish I knew the answer to this. I do not have a political crystal ball, but I can say that this is one area where we can make a difference. So if you're a dreamer or you care about dreamer issues, get on the phone, call your congressperson, call your senator, especially if they're Republican, and let them know you want HR 2820. You demand HR 2820 and a path, a solution for dreamers. Next question. Does a DUI misdemeanor from a long time ago qualify? Great question. Unfortunately, not enough information here about the misdemeanor to really be able to answer it. There is a portion of this act that states that people who are inadmissible under INA subsection A2, okay, which is basically includes crimes of moral turpitude, that they are not eligible for the act. Some DUIs in some states can be a crime of moral turpitude. Okay, so it really depends on a few things, whether that's a crime of moral turpitude, whether that conviction was punishable by under a year in jail or more than a year. So can't really answer that question yet with regards to the specificity. Another question, are new applications going to be accepted? I think this question, I think the person or the people who asked this question are a little confused about what HR 2820 is offering. This is not, HR 2820 is not to reopen DACA so that people who applied for deferred action for childhood arrivals can apply again. This is giving a path towards legal permanent residence for dreamers, some of which include people who have DACA. Okay, so this is not a bill that proposes to reopen DACA. Okay, That's it for this video. Two things. First of all, if you like this video, if you're interested in immigration videos, make sure to subscribe to my channel. If you're a dreamer and you're on Facebook, join my group, DACA Dreamers Moving Forward. We talk about these issues. We talk about how dreamers can move forward despite immigration challenges. If you are a dreamer that's in college and you want resources for scholarships and other things that would interest college students, make sure to check out my friend David Morales' app, the DACA Scholars app. Very good app, has a lot of really good, useful information for college students. That's it. Hope you liked the video. Take care.